Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross Jr., President of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Mr. Ross, thank you for
Mr.
coming
York,
on the show
thank you.
today.
Thanks for having me.
So let's just tell our viewers a little bit about yourself that hasn't seen the show yet, okay?
Okay, I'm a local attorney. I have Ross Title and Escrow. We've been in business for quite a while. We've done 20 to 30,000 closings. I'm one of the shareholders at Downing Fry Realty. I've been their counsel for 20 to 30 years, roughly. Staff of 7 people. They've been together upwards or past 30 years with my office manager. 4 of them are actually related. Makes it more seamless that people have been together a long time. Allows me to come here and do things like this. And we hope that we do a good job and keep people happy.
You do an excellent job.
Thank you.
Our customers love you. You return calls, your staff returns calls. So
Thank you,
plus
Jim.
you're the best of the best attorney in Naples and the best of the best title company.
Don't tell anybody.
So you're just voted that in the last couple of
Precious.
weeks. So Don, we want to talk today about the show. We want to talk about addendums and mixing and matching and what should we sign and dates of addendums and everything. So, because there's different various contracts that we use. So maybe you can start with
out with this?
Start out with that.
Well, my visual aid here, Jim, don't
I
get
know.
excited, but this is what I work with every day.
It's tough, isn't it?
Here's all the NABOR forms, and I put them in a loose leaf binder with a table of contents, because there's 70 to 80 forms. And then here's the Florida Association of Realtors and the Florida Bar. And so the realtors are constantly dealing with all this stuff, and sometimes they'll match forms from NABOR, and they'll use it in FARBAR, or
That's
try
right.
to use FARBAR, use it with NABOR. And if you don't know what you're doing, and you don't know when the last extension was, you're going to get sued. You're going to miss something.
And that's the truth, because I mean, these are written. I was on the committee, the Legal Resource Committee for our local board for 8 years, and it's attorneys and there's some agents on there like myself, and it's complicated because it's really written by attorneys. They get our input, but it's written by
It's written by attorneys, and a single word could mean so much more to an attorney than to what I call a normal human being.
That's true.
No offense to attorneys, but
No.
we're not quite normal. But I get a lot of questions about what's an addendum, what's addenda, or what's amendment. Should I use the amendment form versus the addenda? And honestly, since I get that probably every other day, if I could hit that first, addendum is just something that you add to the contract.
Mm-hmm.
It's a Latin phrase. You're adding.
And
add.
there's forms for certain
Yes.
things, right?
I mean, if it's something that's not covered within the boundaries of the contract, like the seller's ability to stay longer, that's an addendum.
That's right.
Okay, but if there's more than one addendum, the plural is addenda.
Mm-hmm.
It's a Latin plural form. An amendment is when you change something. We're changing the closing date from Friday to Monday.
Mm-hmm.
You're making a change. Now, I had this yesterday, and NABOR happens to have an amendment form that just has the name of the parties on the top, and they have a big blank area.
That's true.
And the people
Yep.
sign at the bottom. And one realtor was giving the other realtor a hard time because they were adding something to the contract on the amendment form. And I, what was my opinion? I said, well, technically it's an addendum, but the court won't care. It's a distinction without a difference.
Mm-hmm.
If you're saying something basic like the buyer will also get the kitchen table,
That's right.
and you're putting that on an amendment form, I think the court can look at this amendment form and say, yeah, technically it's not an amendment, but we know what the intent of the parties was to get the table to the buyer.
Well, why can't you put that on the last page under comments?
You can.
'Cause that's what we do, to be honest with you. Like we just did a contract, and they said furniture included, but we wanted to make sure the TVs
Sure.
were included. So we just put it on there that TVs will also be included.
A lot of times it's like 3 days after you have a fully executed contract,
Right.
and they might have had an inspection, and they didn't know the mirror in the bathroom was hanging on a hook, so
Right.
they want to make sure they get that.
Okay.
Okay, so it's something after the fact usually.
Okay.
But they argue about whether you're calling the horse a horse or a moose. The judge can look at it and say, it's a horse. I don't care if you call it a cow, it's a horse. So it's the substance, under the body of case law that prevails over the form. I mean, you see that in the Internal Revenue Code, you see it in the case law. The courts will always apply the substance over the form. So just calling it
Whatever.
cow
Right, yeah.
doesn't make it a cow. It has to actually be one. So they'll look at what the parties wrote to determine whether or not, the proper name was applied to that. And they'll try to implement the intent of the parties. So it really doesn't matter a whole lot. So that's my first thing. And then what we see a lot of is, because we have all these NABOR forms and we have all these forms from the Florida Association of Realtors and the Florida Bar, or FAR Bar, the realtors, the customers, they'll use the wrong addendum. It might be a NABOR addendum with a FAR Bar form. And the really big danger in mixing and matching NABOR and FAR Bar is the addendum or the amendment might refer to a paragraph in the NABOR contract.
That's right.
And when you attach it to a FAR Bar contract, you're committing malpractice because there is no such paragraph. And plus it makes you look unprofessional. You don't know what you're doing.
They're two completely different contracts.
They're totally different. They have different paragraphs. They have different definitions of what's defective. A lot of differences. So you just don't want to look. One, you don't want to make a mistake that costs your client money, because then you're in trouble. And two, you don't want to look like you're unprofessional. You don't know what you're doing.
Why would somebody do that? I mean,
They couldn't find the form under
is that-
FAR Bar.
Okay.
I mean, FAR Bar doesn't have everything NABOR has, and NABOR doesn't have everything FAR Bar has.
Okay.
So they get frustrated, and on top of that, I mean, almost every question I get, it seems to be, I'm in my car, and whoever will start with the question, and I'll have to interrupt and say, what's on the bottom of page 1? Because I don't know which contract the question pertains to.
Right.
Does it say the National Association of, does it say the Naples Board of Realtors, or does it say the Florida Association of Realtors and Florida Bar? So I know which one. If it's the Florida Bar one, does it say as is? Because that's the one they most commonly use. What are the dates on the bottom of the page? Because they have copyright dates. They have dates of when the contracts were last revised. For example, NABOR was revised in 2019. It'll say 1/1/2019. FAR Bar was 2017. And I'll see things where, I mean, I've had people bring me, forms from like 6 years ago.
Yeah, usually, not to interrupt you there, but usually back years ago, before we were high tech with using the computers and much.
Sure.
Real estate offices used to have the contracts in their offices.
Right.
You could go in
Oh,
there.
I remember that.
Pull
Right,
them
right.
off, okay?
Right.
You wouldn't have to make copies. They'd supply you that. And then when there was a change, there's people that grabbed a bunch of them, put them in their house or their office or wherever, and they would be using old
Those are the good
forms.
old days.
Right, those are the good.
I remember those
Today,
things.
it's
They were right above the copying machine
Right.
in the old Downing
You-
Fry office,
you're
those
exactly-
slots in the wall.
you're exactly right. So,
Yeah, that's we had a form lease too that people would use.
so
But and the other thing you look for, not only what's on the bottom of the main contract, but if you have attachments, which could be an addendum, an addenda, which would be plural,
Right.
or an amendment, are they the same dates?
right,
Because you'll with FAR Bar or NABOR, you could have
two different. right.
the seller financing addendum changed with Dodd-Frank in 2015. There was about 6 months where they didn't even have one for either of these contracts because they had to make up the form to comply with federal law. So you want to make sure you have the most recent copy on the main contract and that the attachments match. Now, if they want to be the most current, and if you're going to mismatch NABOR and FAR Bar, you definitely want an attorney to do it. I mean, there are some forms you can do that with,
Right.
but you as a realtor or you as a layperson, won't know the contract as well as an attorney. You know, thank goodness. Who would want to other than an attorney?
Yep.
If you're going to mismatch, you want to do it on purpose, and I've done it. But I've always said to the other side, I know these don't match. I'm doing it on purpose. Because I always anticipate they're going to call me an idiot for, that doesn't go with that. I says, I'm doing this on purpose. For I have my own reasons. I've discussed it with my client, and there's no cross-referencing the main body of, say, the NABOR contract if I'm using the NABOR pre-closing occupancy form, which is what I used, on a FAR-bar contract. There isn't. But there's a legal advantage to doing that if you're representing the buyer.
Well, Don, before we continue this, we're going to take a little short break. And we're going to hear a little bit about the York Real Estate Group, and we're going to hear a little bit about Don Ross title closing, okay? We'll be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Well, Don, let's continue this conversation and just give our viewers a little bit, some examples of different forms that we use, okay?
Well, with FAR-bar, they list in paragraph 19 all the different addenda in terms of ones most frequently used. So condominium is first, homeowners association is second. The condo rider is 3 pages long. I like it. It gives the buyer more flexibility. It requires the seller to disclose if there's been any discussions at any homeowners meetings within the last 12 months of a future special assessment. I mean, that's something that seems to come up a lot in our business. You know, there's been discussions and then the buyer finds out about it after the closing. It gives the parties the flexibility to negotiate who's going to pay the periodic payments that might be due on a special assessment. Let's say you have a $1,500 special assessment, which we had in Pelican Bay at one point. It was payable $500 each year. Under the FAR-bar contract, you can check off that the seller is going to pay for everything up to the closing date, but not after, or you can have the seller pay for the whole darn thing. So it gives you that flexibility. Whereas NABOR, it's standard I in the contract. It's 1 paragraph. It's about that big. It's the bare bones, which in some situations is good.
Right.
You don't want to get too crazy sometimes, but it's that big versus 3 pages. So
what's that paragraph say?
That's paragraph I. The homeowners association says standard H. So I always remember for homeowners it's H, and condo is right after that. So there's radical differences. The pre-closing occupancy that I referred to in the prior segment, and the post-closing occupancy, just for those who don't know, the pre-closing allows the buyer to move in before closing, and the post-closing occupancy allows the seller to stay some period of time after. Now, the big difference between the two, and I've mixed and matched these forms on purpose, and it was a FAR-bar contract, and I used the NABOR pre-closing occupancy. Why? Because that form does not require the parties to execute a lease. And if you don't have a lease, the owner of the home or the cannot get an eviction hearing. They don't get that expedited hearing before the judge. They have to go for ejectment, which takes the normal length of time that you would have for, say, a breach of contract case.
Right.
So I had a buyer who was buying over in Coral Gables, and you know, rather than using the FAR-bar pre-closing occupancy, which required the parties to actually agree to a lease within 10 days. I used this one to buy my client more time in case there was a delay. They wouldn't be able to get him out in a hurry. And I prefaced it when I sent it over that, because it was in Miami, basically, said, I'm doing this on purpose because I really didn't want to hear from some Miami attorney saying you're crazy, you're using the wrong form, you don't know what you're doing. I said, I'm doing it on purpose. But that's something lawyers would know, so you want to use a lawyer for something like that. We know eviction versus ejectment. Nobody else really knows that. Also, there's a lot of risk with waiving any contingencies or any repair obligations or any obligations to maintain the property if you move in early. But the main reason that there's a risk with moving in early is that inevitably the buyer will find something else wrong that Alan, or whoever the inspector was, Alan from Janus, they'll find some squeak in the middle of the night and it drives them crazy, and I'm not going to close unless you fix that thing, and they've already had their inspection. So getting them in there early is no real benefit to the seller. Sometimes we'll amend the agreement so that they can just move their furniture. Sometimes it's, they're moving it down from New York or someplace. But those four, will interchange all the time. I'll use the FAR seller's disclosure rather than the NABOR one, because the NABOR one has the provision above the buyer's signature that if the buyer signs, anything that's listed as broken is no longer considered a defective item.
Right.
And that, if they're going to do it, I want them to know that that's there. If in doubt, I'd just say don't sign it.
Right.
Don't sign it. So, don't mix and match. Call me, call some lawyer. If you are going to mix and match, don't get too hung up on whether it's an addendum or an amendment. It's the substance of what's said. And even the substance you want to run by an attorney, because I get too many situations where, the language is the buyer wants blah, blah, blah. And that's not an agreement. That's what we call a precatory wish. I want to win the lottery, but doesn't mean I'm going to win it. So the buyer wanting something doesn't mean the seller's agreed to give it to him. So we tighten up the language to make it an obligation.
You have to do that. I mean, we might write it up and then send it to you, and then you tweak a little bit and send it back to us, or call us
change
on the
the
phone.
verbs, make it an obligation.
Exactly. So, because something, that's your business.
Yes, language
it's not
is our
business. We're
no.
not, so that's something that I think is a key thing, trying to do it yourself.
Yeah, so, brokerage firms will tell their agents don't mix and match because they don't want them evaluating whether it's referring to a paragraph that doesn't exist. And the other biggie that happens all the time with the as-is contract and the NABOR contract, people tend to use the buyer's election seller's response form in the as-is contract.
Right.
And that's just flat malpractice. I mean, it makes reference to section D2B of the contract, and there is no D2B in the as-is contract. D2B is in the regular NABOR contract, which defines what's defective.
Right.
There is no definition of what's defective in an as-is contract.
Yep.
So you don't want it for that reason, and you don't want it because there's language on the bottom that says the buyer has 5 days to cancel if the seller says no. And I think you asked about that in a prior show. What happens after the 15-day due diligence? Right. It's too late.
It's too late.
It's too late. There is no right to cancel. Right. So mixing and matching can get you in trouble. Using the wrong forms for the wrong contract, even within NABOR, can get you in trouble. Have somebody you work with that you can pick up the phone and ask, will this work?
Well, you got to work with people like us that's experienced and that knows the contracts, because people that are getting in the business, there's a learning curve to anything. So it's just look at those books. What's there, 75?
It's at least 75 in each one.
In each book, right?
And it's not that we know everything, but at least you and I can spot the issue, and then we can go look it up.
Exactly.
We know there's an issue, whereas a normal person won't know. That they'll think it's fine.
Yeah, experience has a lot to do with it. You run
exactly
across
right.
things over the years. So.
Yeah.
Don, thanks for coming on the show. I appreciate it. I'll see you next month. And
thank you, Jim.
Thank you for tuning in. We'll see you next week, okay? Thank you.